And for any young attorneys in here, that's another advantage of this organization. You pick up the phone, or now we have the listserv, you throw an idea out there and you get a chance to get some feedback. I think that's a fabulous thing. Denny has been a former member of the OTLA Board of Governors. He's currently a member of the Uniform Civil Jury Instruction, President's Circle member. I don't think he's going to tell you that he also is a blues aficionado, and he'll go out there and listen to some dirty blues in a smoky bar. But Denny's going to talk to us about medical records requests. Denny?
Thank you, Steve. How many of you attending today attended the summer convention in 2001? Quite a few of you. If you'll recall, there was a panel discussion regarding medical record requests, and I was very much surprised to see the difference of opinion expressed by experienced plaintiffs' lawyers, both as far as what the law was and as far as what their individual practices are. And what I'm going to be discussing today are simply my own views on it. There doesn't seem to be a consensus, but I do think that we have a real responsibility to our clients to do what we can to make sure that their records do remain as confidential as possible. Can you hear in the back? Okay. First of all, the State of Oregon, ORS 195.525, states that it is the policy of the State of Oregon to protect the right of an individual to have the medical history of the individual protected from disclosure. And the medical associations also include in their rules of ethics requirements regarding keeping patient records confidential. And the federal government has passed statutes, including the Health Insurance Portability and Accountability Act, or HIPAA, and a major portion of that act is designed to protect confidentiality of personal health information. So the point of all this is that before there's any litigation, before there's a lawsuit, we do have a very recognized right as a patient to have our records kept confidential. What changes when you file a lawsuit? When you file a personal injury lawsuit, the normal rules of discovery will apply. ORCP 36B authorizes inquiry regarding relevant matters not privileged. And sometimes I think people forget about the language not privileged. So when you're thinking about responding to a request for production based on 36B, it has to be relevant, but it also has to be something that is not privileged. The privilege is not waived by filing a lawsuit. And the Nielsen against Bryson case, a 1970 case, so holds. And that case is still good law. And in that case, I'm going to discuss a little bit the facts about it because it raises another issue about subpoenas. In that case, the defense subpoenaed the custodian of medical records from doctors' offices and from a hospital. And the court held, eventually, that the defendant did not have the right to subpoena those records from medical offices because of the privilege, and that the privilege was not waived. But I think to some of you that have not been practicing when this case was decided, the procedure may sound a little bit strange to you. In 1970, if a defendant wanted medical records, what they would do, besides requesting, is that they would notice a deposition, and then they would serve a subpoena ducis tecum upon the custodian of those records, whether that custodian was in a medical office or whether in a hospital. And for example, in a hospital, when hospital records were subpoenaed, the custodian would show up in person, usually at the plaintiff's lawyer's office out of custom. The custodian would be asked some foundation questions to establish that the records were kept in the normal course, and then the records would be made available for copying. But the practice was that the custodian would bring copies along with her, and then when the custodian left, arrangements would be made to copy the records. In the Bryson case, the doctor's offices, the custodians, were subpoenaed. And if the motion hadn't been quashed, what would have happened is the doctor or a designate would come and be asked about whether or not those records were kept in the normal course, and then they'd be left. The reason I'm going into this in some detail is that all of these procedures have become much less formal. But a subpoena is still a court order. We're still officers of the court. And I think that it's important that we realize that back in 1970, it took some effort to get some records. Now a lot of subpoenas ducis tecum that are headed toward medical providers or hospitals are being prepared by legal assistants, and they're cranking them out on word processors, and it takes very little effort to do so, and it takes a lot of effort on our part to do something about it. There's another case having to do with whether or not privilege is waived with filing a lawsuit, and that is Woolsey against Dunning. It's a 1974 case. And that case held that the privilege was not waived by filing a wrongful death case. And I think it's also important, too, because it emphasized that the doctor-patient privilege was not changed by the 1973 legislation that resulted in ORCP 44C. There have been recent arguments raised by defense regarding a waiver of the privilege by authorizing health carriers to obtain records. These disclosures when a patient authorizes their own health carrier to get copies of their medical records, these disclosures are also privileged. Part of the materials includes an opinion by Judge Edward Jones, McLean against ODS. It's a very recent Multnomah County opinion. Laura Johnson from Eugene was nice enough to get me a copy of that order. I didn't have the pleadings, but I did have the order, and the order itself is in the materials. I want to talk a little bit about ORCP 44 because, from my viewpoint at least, that is what controls the conduct of discovery in a personal injury case. And in Rule 44C, the operative language is that we are to make available written reports and existing notations of any examinations relating to injuries for which recovery is sought. And we're obligated to provide those records. And I think it's a reasonable interpretation of that language to include the chart notes. However, I don't think that this language would be consistent with request for prior treatment records, because those records are not going to be relating to injuries for which recovery is sought. Now, if we fail as lawyers to provide these records, the defense does have a remedy, and that is to file a motion for an order compelling discovery. The remedy is not to send out a slew of subpoenas to outpatient medical providers. I'm aware of no rule and no statute that authorizes the defense to subpoena outpatient treatment records so long as the privilege has not been waived. I mean, that's 44C, and you're all familiar with that. Rule 44E is the subsection that deals with hospital records, and basically simply says it's subject to Rule 36B. You can subpoena hospital records. What a hospital record is should be pretty straightforward, but hospital records are defined by ORCP 55H and also by ORS 442.01514. And outpatient records, records for outpatient treatment are not within the definitions of a hospital. So doctors' offices, chiropractors, acupuncturists, physical therapists, all of these things are outpatient treatment. They cannot be reached by 44E. As part of the materials, I included a case that was one that I was handling in Clackamas County a few years ago, Gagne against Royce. And it demonstrates the difference between inpatient and outpatient records. My client had been treated at Kaiser since he was a teenager. He'd been going to various clinics for over 30 years. He was involved in a motor vehicle collision in Clackamas County, lived in Clackamas County, defendant lived in Clackamas County, and so I filed a lawsuit in Clackamas County. During the course of discovery, the defense served a subpoena ducis tecum, or sent me notice of their intent to file a subpoena ducis tecum for any and all medical records at Kaiser. I talked to my client about it. My client didn't feel that it was appropriate that all of his records relating back to the time he was a teenager be poured through because he was involved in a motor vehicle collision and in a lawsuit that was pending in 1996. I wrote a letter to, well, I called first. I called opposing counsel and explained that I felt that the subpoena was too broad. It should have been limited to hospital records. At Kaiser, as a lot of you know, they keep the inpatient records and the outpatient records in the same medical records library. They'll have a big folder with all the inpatient admissions, and then they'll have another folder with all of the outpatient records. Opposing counsel was not agreeable. I wrote a letter pointing all of this out. He wrote me a letter telling me pretty much to take it up with the court, and so I did, and filed a motion to quash. The Clackamas County presiding judge granted the motion to quash, and as part of his ruling ordered that any further subpoenas pursuant to Rule 44E were limited to inpatient and ER records relating to injuries for which recovery is sought in this case. The defense attorney was not pleased with this ruling and petitioned the Supreme Court to review the trial court's ruling. It was briefed by both parties, and amicus brief from OADC, and the Supreme Court denied the writ of mandamus, and so that Clackamas trial court order stood. And the relevant parts of that are part of the materials. Now, part of the argument that we face when we find a notice from opposing counsel that they're going to subpoena these outpatient records is that it's authorized by ORCP 55I. It doesn't do that. Rule 55I is included in the materials, not with mine, but in connection with an earlier presentation today. It's a lengthy provision and essentially provides a procedure that makes it possible for patients to challenge unreasonable subpoenas before whoever is seeking the records has them in their hands. And it's a notice requirement that is imposed upon anyone issuing a subpoena for any patient or health care recipient. This legislation was passed in 1995, and there wasn't a lot of legislative history about it. The Oregon State Bar indicated that in its publication about the 95 legislation, said that its purpose was to protect patient privacy by giving a patient time to assert any privilege before the medical records are produced, and also to relieve doctors from the obligation to inform patients of the subpoenas that are issued for their records. And even though a lot of doctors may not have done this, I think it was their obligation. And it also protected doctors because the notice requirement was in effect done for them, so that they would not be subjected to the claims of invasion of privacy. I think that the defense argument that 55I is a wholesale grant of authority to subpoena records is flawed. The statute is not limited to personal injury cases or even to litigants. It would authorize discovery even when no claim for injuries was made, and would defeat the primary purpose for the rule, which is to protect patient privacy. As a practical matter, when we're dealing with these things, we get requests starting with the liability insurance carrier. And last week I got a request from a liability insurance carrier, and I just wanted to read a little bit of it to you. It's sort of like maybe reading your own insurance policy or something. This was sent to me with the request that I have my client sign it and return it to the liability insurance carrier. I authorize any, and then there's a laundry list of medical providers, but it also includes federal, state, or local government agencies, insurance companies, consumer reporting agencies, employers, former employers, having information as to diagnosis, treatment, or prognosis with respect to any physical or mental condition, any non-medical information about me, including any information regarding my occupation and salary, and including information with respect to HIV infection, AIDS, mental health, and alcohol and substance abuse. I had occasion to talk with the adjuster, and I said, "You're kidding, right?" And he told me that I'd be surprised how many of these he gets back. And so that's the reason I took the time today to discuss it, is because we don't want to do that. We don't want to send off these types of releases that would obviously give great opportunity for mischief. So we just have to say no to these requests. There's another, well, besides the abuse of the client's privacy, it's also a bad precedent. It's our job when we have a personal injury case to get the medical records. We review them. we make sure that we provide everything that the rules require of us to the other side, but we also need to protect our client's right to privacy. In some jurisdictions, this business of giving insurance carriers and defense attorneys releases has become so prevalent, it's become standard practice. And courts will require plaintiffs to have their clients sign releases for this purpose. And that isn't something that we want to have happen in Oregon. And when your client comes in, make sure that your client hasn't already signed one of these releases, and if you suspect that your client may have, write the carrier and rescind that and insist upon receiving copies of any records that may have been obtained with such a release. Now, I know that request for production in litigation context has been discussed earlier. I'm going to limit what I have to say just to 44C. What my own practice is that if a request is broader than authorized by 44C, which is virtually every single request that I get, I object, and then I agree to provide records using language consistent with 44C. And then sometimes I get a phone call from opposing counsel, and I'm sure that many of you have heard the same responses. The first one is, how can you deny that these records I'm asking for are relevant? And of course the answer is, I'm not saying they're not relevant, you're just not entitled to them. They're privileged. We don't have to get to relevance because they're privileged. And then I hear, well, your client is suing my client and therefore waive the privilege. And I think just about all of the defense lawyers that I deal with know that isn't the case. But it's still what we hear. Now, having said that, I'm not saying that we never provide some of these records to opposing counsel. I'm just saying that if we do provide these records, it's because we feel it's the right thing to do in the case, not because we're required to by these discovery rules. I do want to say just a little bit about the Multnomah County body part rule. I think all of us who practice in Multnomah County are familiar with it. It's contained in the Civil Motion Panel Statement of Consensus, and pretty much the statement is that the court will ordinarily require records relating to the same body part or area. I simply don't agree with that. I think that is inconsistent with Rule 44C. Rule 44C could have been written that way, but it wasn't. And so I don't think that Rule 44C should be construed in that fashion. I suspect that the original court ruling originated out of a pragmatic concern that cases get settled, because I think a lot of the judges feel that we need to get more cases settled. And for example, if there is a prior injury to the same body part, how is the case going to get settled if the plaintiff doesn't make that information available? And I think that in many occasions that's true. I frequently make records available that are beyond the obligations imposed by Rule 44C. If relevant medical records regarding a prior medical treatment are necessary for evaluation and settlement is a realistic possibility, I always make those records available. You have to stop and think that if settlement is not a realistic alternative, whether or not that is something that's in your client's best interest to do. Also, if relevant medical records about a prior condition or a prior injury, if that information is going to be relied upon by your expert you're going to give the expert those records. Those records are going to be available to the defense when your expert testifies. The defense attorney and his expert will have the opportunity to review those records, and by not making the records available, you're probably just delaying your own trial and making it seem like you're hiding the ball and making it unlikely that there can be any settlement discussion. So there are situations where you should, I think, because it's in your client's best interest, provide some of these relevant records. Not because we have to, based on Rule 44C, but because at some point it will be in your client's best interest for you to have done so. Now, sometimes rights that are important to us are affirmed in different ways, and when I was preparing some of this material, I remembered a case that I handled a long time ago, and I felt that it was really an affirmation of the importance of a patient's right to privacy. I represented a patient at a hospital who suffered a fall, and the fall was in a four-bed ward. There were 3 other patients in the hospital at the time that were probable witnesses. I sought discovery of those 3 individuals, and the defense for the hospital did everything possible to protect the privacy rights of these witness patients, including their identity. And so if the defense can recognize the privacy rights, even where it's clearly relevant, we owe that to our clients, and we need to protect our clients' rights to privacy with as much vigor. Do you have any questions? Bruce? Well,
I'm thinking of actually having my paralegal bill for her time, as well as any charges we're getting from these medical records providers.
The question is, how am I handling obtaining all of these medical records from providers because of the cost involved? And in the past, I think I have been a little bit too generous with the defense, because I think historically we have pretty much traded exhibits and traded discovery. As the demands for discovery has increased, I think it is appropriate, and I've recently done a little bit of informal survey to see what other attorneys are doing. And I'm finding that more and more routinely attorneys are charging for some of the costs. Now, I've been basing the costs upon cost of reproducing the records, not getting the records. Now, maybe part of what you're asking is, a lot of times in the request for production, there will be a request for narrative reports. My typical response to that is that if there isn't adequate information provided by the doctor and the defense wants a narrative report, I agree to provide it. After they identify the physician from whom they want the report, and after they've made advance arrangements to pay for that report, including the cost that the doctor charges for preparing the report. And I have never had anyone ask, ever.
How are you handling the multi-purpose doctor's visit and the motion panel for where your client goes in for 3 or 4 different issues, one of which may be that which you seek to recover?
I haven't really had a situation come up where I felt it was detrimental to my client not to make most of those records available. And so I think for the most part, where there are some incidental treatment, I'm providing that. And I try to touch base with my clients too. Sometimes these things are just going to come out, and even though we want to protect our clients' right to privacy, there's only so much we can do. And another limitation is we can't get involved in discovery war in every case either. But I think it is important to draw the line and to do what we can to protect our clients' rights.
Thank you, Danny. Our next topic is something that's probably near and dear to all of our hearts. And for all of you that have seen me on the listserv, you know that it's also near and dear to my heart, and that I'm sort of tilting into windmills at this. And I'm going to tilt a little bit before I hand it over to these two guys, because I still think that there is a fundamental question that needs to be asked before we start talking about conditions of DMEs, and that's whether the damn things ought to occur at all. And I still continue to think that if you look at ORCP 44 as a continuum, as Denny Skarstad just told us about, that the defense has the right to get all of the records, and particularly if you've been cooperative and you've given them all the records, and then they sit there and they subpoena all the same records that you've given them anyway, and they have the opportunity to ask a competent treating doctor who has no axe to grind for a narrative report. At that point, don't they have all the information they need to examine your client and to really understand what their injuries are? Yes, they do. And all they're doing is they're getting themselves an advocate witness. And I think that that is not what the rule is designed to do or supposed to do, and it's not a good cause for having the examination. Having said that, I haven't succeeded on this argument yet. But I want to keep trying, and I'd like to encourage all of us to consider trying it in appropriate cases. I've got all the mandamus material ready to go. And it's available for anyone that wants to fight the battle. And I'll be there, and I think the amicus committee will be there to help you as well. Having said that, we have two people that know a lot about this subject, Tom Diamore and Peter Glazer. Tom is a member of the OTLA Board of Governors, member of the President's Circle. Peter's a member of the President's Circle. They have done a lot on this. They're part of the DME task force, and so I will turn it over to them.
Thank you. I wanted to make two comments before moving to DMEs related to the uninsured and underinsured motorist topic that Mike Bryan talked about. If you look at your own umbrella policy, and a lot of people in this room have an umbrella policy, look at it or ask your agent, as Mike did, to find out whether you have UM and UIM in that umbrella. It's in most state farm policies. It's not in most all-state policies. Depending on which insurance company you have, you may not be providing your family the best protection that exists. And I also want to thank Mike for his presentation and talk about this Mosley and this notice issue. I know that's not my issue, but this proof of loss and proof of claim is something that everybody ought to be doing and everybody ought to be paying a lot of attention to. I try to slip it into an early letter when I'm sending a letter to a PIP carrier. But read Dawkins, which is in those materials with Mike Bryan's materials. The Dawkins Supreme Court opinion from 1999 talks about a proof of loss, talks about the burden on an insurance company once it has notice of a claim to go forward and investigate. And your client, of course, in a UM or UIM situation has a duty to cooperate, to sign an authorization. So the insurance company really has everything they need when they have the PIP application. I get to go first here before my friend Tom Diamore, because if I didn't, I wouldn't get a word in. Tom got to give a presentation, and I don't know how many of you in this room were there. I don't think anybody. He got to give an all-day CLE, 7 or 8 hours, on the topic of UM and UIM about a month and a half ago, and he just almost single-handedly talked for 7 or 8 hours on UM and UIM. So I knew that if I didn't go first, I would not get a word in edgewise. Well, on the topic of DMEs and IMEs, I want to start by reading you a quote that is in the materials that some people have heard about. Some people question whether it really is true and exists in the world, and it does. And this is what it says. Columbia Medical Consultants, Inc. has taken a whole new approach to the way independent medical exams are currently being conducted. Frankly, we don't believe there should be anything independent about an independent medical examination. That's right. That's exactly right. That's the problem. And that's an ad that I found in a claims adjuster's manual about 5 or 6 or 7 years ago, and used against that Dr. Merritt Quorum and his outfit, then known as Columbia Medical Consultants, in a case with Allstate. The whole problem of DMEs and IMEs is that they are not independent, and we know that even if they are independent, there are some inherent problems with sending your client without a tape recorder or without an observer, and the doctor sits there and asks questions which can include innocently improper questions or questions that might be known to be inappropriate by the doctor. The doctor can misunderstand things, and if you look at the history that you see in most IMEs, there's always something wrong. You know, it was a broadside accident when you know that it was a rear ender, or it occurred on Southeast 17th and you know it was on Northwest 14th. Whatever it is, the doctor always gets something wrong. So there's a lot more than just the stuff you can objectively prove in that history. Improper questions, doctors taking what amounts to a second deposition, simple misunderstandings by a doctor, those were the problems that led some of us to start years ago to try to find some kind of solution. And as I indicated in my materials, my initial approach was to be just about as unilateral as most defense lawyers were. They would write me a letter saying, on such and such a date, at such and such a time, at such and such a place, your client will need to be present to be examined by Dr. Jones. And they didn't call and say, you know, we'd like to do it at such and such a time, what would be convenient. And they didn't follow the procedure of ORCP 44, which of course, you know, sets out the requirement that Steve Hendricks was talking about for good cause, and requires setting out the scope and conditions of an exam. So the procedure to just show up or have my legal assistant show up worked in most cases. It didn't work in all cases. Sometimes the doctor would refuse to go forward. Sometimes I'd get a call from the defense lawyer, and sometimes when I was in the office I didn't take a call from the defense lawyer at that time and talk about it, and then the doctor sometimes went forward anyway. But that worked, I guess, for years. It seemed to work satisfactorily. The doctors weren't real happy about it, but if you read a couple of things in my materials, I think at least the affidavit of Craig Showerman, my friend over in Vancouver, and maybe the affidavit of Judge Schemas, or declaration of Judge Schemas, you'd know that these same Portland doctors that were having so much trouble agreeing to conduct an exam with an observer present or a tape recorder going, we're doing it all the time for Washington cases, because that's simply the law in Washington that you have a right to have one of those, or maybe both of those. In any event, we finally, Oregon trial lawyers finally got active on the topic, and 3 or 4 years ago we formed a task force and tried to deal in an organized fashion with this whole problem. And the task force decided that the best approach was to go to the Council on Court Procedures and to try to accomplish a change in the rule that would make it very, very clear that you had a right to have an observer present, and you had a right to at least make some kind of a recording of an IME or both. And the Council on Court Procedures, it's a long story, but the bottom line is that by a 1-vote margin, it failed to get the supermajority that is required. You essentially have to have all the plaintiffs' lawyers and all the judges. There basically are 3 different components to that council, and I don't know who they didn't have, but they didn't have that 1 extra vote that was necessary to have the supermajority. So there wasn't a rule change accomplished. As we talked about this whole idea of what to do, there certainly was risk, and more people were doing something about IMEs or DMEs themselves, as I had done, sending someone along as an observer or having a tape recorder with your client or maybe with an observer. And there were some adverse consequences. I got chewed out a little bit by a Multnomah County judge, and then another lawyer posted something on the listserv about getting sanctioned several $1,000s by a Washington County judge. And I don't know the exact circumstances, but it just wasn't something you really wanted to experience again or firsthand. So we developed an idea. I know on the listserv there was talk about coming up with a letter where if you got a letter from the defense lawyer saying on such and such a date, such and such time and place, there was going to be an exam of your client, you would write back and you would say, well, okay, here are the scope and conditions that we're going to agree to be there. And basically you're saying, well, if you don't care about filing an ORCP 44 motion to have an exam, you just want to tell us when to be there, and you're not going to set forth scope and conditions of the exam, these are the scope and conditions we want. And then you get into some discussion and perhaps some negotiation with the defense lawyer. There are attached to my materials as Exhibit DD two of these letters. One of them's mine. I think the other one came, well, I don't remember, from Mark Ginsburg or Jeff Foote's office maybe at that time. But in any event, there's an idea of what you can do if you want a slightly less confrontational approach than simply to send someone along and surprise the IME doctor and the defense lawyer. If you do have to go to court on an issue involving a DME, the scope and conditions of a DME, I think that it is highly appropriate. It's kind of what Dennis did in some of the materials, is to give you trial court orders that show that judges have gone the right way on this issue. And with the first orders that I heard about or that I got, I kept trying to use those again and again to convince a judge that they really weren't out in left field if they ruled my way on a DME issue. So in your materials you have virtually every order that I was able to collect that I thought has anything to do with the scope and conditions of a DME. And if you go to court and you have an issue about whether you can have an observer present or whether you can tape record or even videotape that exam, I would suggest that you attach those trial court rulings from other judges, and these come from all around the state. There's one from Astoria, there's one from Jackson, one from Josephine. They're all over the place. These are judges that have made the same kind of ruling. They're not always the same issue, but they'll be supportive. On the good cause question, Steve Hendricks wrote, I think originally wrote the language that I plagiarized, and you'll find in a memorandum that's in my materials. And then there's a discussion of some of the other issues in there, and there's some briefing whether it is current or not and whether you need to update it. I think you might. But there's some discussion about the question of whether you can have an observer present. Oregon law has really 3 different cases that bear on this topic, and I think there are really literally only 3. The most recent is the workers' comp case of TriMet versus Albrecht, which is now about 10 years old, 12, 13 years old, and simply said that in a workers' comp case it was appropriate for a lawyer to accompany the client to a medical examination, even though the defense argued that that would cause obstruction of the examination. And then Pemberton versus Bennett's the case everybody always talks about. That one's now almost 40 years old, 1963 Supreme Court decision that was equivocal, really. It simply said there are certain occasions when a trial judge might determine that having an attorney present for an examination was a reasonable request, but there was certainly no bright line rule set forth in Pemberton. And then there's this old case that's just kind of interesting to read from 1937 when they didn't have a rule about IMEs or DMEs. The court inherently of its own authority decided it had the power to allow a so-called independent medical exam, and I'll bet it was in that day and age fairly independent. You know, the judge knew the doctor that the judge was appointing to do it, instead of it being somebody that is a hired gun who happened to advertise that he did it you know, cheaper, or consulted the adjuster first, or whatever the current marketing technique of some of these doctors is. The general rulings that you get from some courts are summarized in my materials. The motion panel in Multnomah County has taken a position, and it's the only printed rule that I know of. And remember that the Multnomah County motion panel statement of consensus isn't really a trial court rule. It's just an indication of what judges have done in the past. But that's attached as Exhibit CC to the materials, and the rule says audio recordings have been allowed absent a particularized showing that such recording will interfere with the exam, videotaping, or the presence of a third person has been denied absent a showing of a special need. For example, an especially young plaintiff. I surveyed judges by writing to the presiding judges in a few counties, got a couple responses, and I put those in the materials. In Washington County, Judge McElligott basically said that rarely are they allowing an observer to attend. They usually allow an audio tape and have never allowed a videotape, and he addressed the transportation question, which is whether somebody has to drive all the way down from Hillsborough or somewhere in Washington County down to Salem, and he said that they thought that was acceptable. And in Salem, Marion County Judge Paul Lipscomb said that sometimes the rulings are that you can have an observer present, sometimes a tape recording, audio tape recording, and never a videotape. In my materials, I addressed the question of who you would have attend, and that's where I know that Tom and I may have a disagreement. I don't think that as a lawyer you ought to go, and I don't think that you ought to send another lawyer from your office. I think sending a legal assistant is probably fine, and I took the names that Don Jacobs had posted on the listserv a couple years ago and put those names and phone numbers in your materials. These are nurses that, at least as of a couple years ago, Don had said were resources if you wanted somebody to attend an IME. And then I have this one final thought, and if you've read it, you know that I might not be entirely serious, but I'm pretty serious, and that is if you do ever have a judge, I mean, look, we have a right to know what goes on at that DME, and if you have a judge that ever says, no, you can't have an observer, no, you can't make a tape recording, you have one other alternative, and that is simply to instruct your client to take copious notes. As slow as that process might be, write everything down. And I would imagine that that will be one of the last times that that doctor takes that position, that defense lawyer takes that position, because an exam that otherwise supposedly takes an hour and in reality takes 15 minutes is going to take 6 hours. It's going to cost a lot of money, or it's going to disrupt the doctor's schedule. But you simply have a right to know what went on there, and if that's the only way to make that record, have your client make really, really good notes. Thank you.
Thank you, Peter. Peter and I have done similar presentations like this before on this DME topic, and I'm sort of like the bear cub or the bird in the sky that comes in after he is done and spent all the time on all the topics and has eaten the entire carcass, and then I get whatever piddlings I can get. CMEs, DMEs, IMEs must be by court order. We've heard a lot about that, and we heard Steve talk about that too. I don't spend a lot of time on the good cause requirement just because the judges, if you've got a personal injury case, for the most part, they are going to allow the DME. The main thing that Peter touched on is to get the stipulations. Again, they must have a court order to have a DME. Yes, we agree to them, but they must have a court order if they don't agree to our stipulations. And so you want to lay out stipulations in a letter as to what is going to happen at the examination. And if they don't agree to it, then they need to get a court order. You know, some of those things that you want to have in the report, in other words, you want to have the report within a timely manner. A lot of times they're doing these things 2 or 3 weeks before trial. I want a stipulation as to when I'm going to get that report, or that doctor can't be used at trial. I want to make sure that they're paying for the report and that the report gets done. I want to go through the manner in which the examination is going to take place. If there's depositions and multiple reports in the case already from other providers, I don't think they need to take a history of the client. Again, I think the judges are not going to agree with you on that for the most part. I want to know precisely where the location is, the date it's going to be. I want it to be on my client's time, not some time that they've given me in a letter. I want to talk about recording, and I want to talk about attendance of an attorney at the examination. And if there's a concern about whether the attorney is going to become a witness by going to the examination, make that a stipulation too. I don't really have much concern, and I'll get to that later. Non-ORCP 44 exam, the PIP exams. For the most part, those are becoming pretty routine in auto cases. How many of you just routinely send your clients, to the PIP exam because you got to continue the benefits? How many? Pretty routine. You got to continue the benefits, send them off to the PIP exam. What I'm here to tell you is you need to weigh that very heavily. You can't just send your clients to the PIP exams anymore because their benefits are going to be denied for the most part. How many of you in the room have sent your client to a PIP exam and you came back with a pretty good report? Well, there's a few of you. I don't get too many good reports. I get a lot of bad reports. And how many of you are getting requests for PIP exams within 3 or 4 months of the injury? Okay? And you get a lot of bad reports. For the most part, your case is over after the PIP exam. Unlike Steve Hendricks and Rob Wolf, who don't settle cases, I'm just a mere mortal that settles cases. And if the third-party carrier or adjuster has a bad PIP IME, they can use that against me, and they do use it against me, even if they don't say so. Why should they be telling their boss or supervisor to pay out big on this claim when some medical provider of the insured's own company is telling them there's no injury or there's minor injury? So you may have a good case, but 3 or 4 months into it, you've got a doctor already saying this person doesn't need any more treatment or he needs 2 months more treatment. So you may have a serious injury, and 6 months into it, you've got a report in your file, and the defendant will eventually get that report that says that your client doesn't need any more treatment. So weigh that decision very heavily. And I think the same stipulations apply for an IME exam. You need to be there sometimes or send somebody there to make sure you know what's going on at that exam. My dream is that in California, not only are you allowed to record and not only are you allowed to attend, but you can videotape. So at trial, I want a videotape. I want Troy, Moody, and Nagley to videotape that thing so that at trial I can compare the report with what actually happened at that IME. In some cases, that's going to be very helpful to you because some of these guys, believe it or not, and gals, don't tell the truth, these doctors. And Peter talked a little bit about the olden days. I think back in the olden days where a judge assigned a doctor to examine the plaintiff, then it was pretty fair. I mean, you might get a bad doctor or a good doctor, but the judge has appointed the person. Nowadays, when people are getting paid to do these, doctors are getting paid to do these by one side, how can it possibly be objective? When these doctors, a lot of them, are making $700,000 or $800,000 a year doing these exams for insurance companies, how can it possibly be objective? So the older cases in Oregon where there was the Pemberton case where there was even a statement that, these are non-adversary proceedings, these IMEs and DMEs, we all know that's not the case anymore. The majority of jurisdictions, and I did a little mini analysis of cases across the country, do permit recording and attendance at IMEs/DMEs. We all know that there's a cottage industry. I talked about the doctors, but the biggest cottage industry are these companies that put up these doctors or have these doctors on their payroll, and they put them up for the insurance company to do the exams, particularly in the PIP context. The insurance companies and defense lawyers like to deal with the companies as opposed to the doctors. Sometimes they do contract directly with the doctors, but not as much anymore. These are million and billion-dollar companies that all they do is examinations for insurance companies. So you need to pursue that issue in cross-examination too. The reports that are done, a lot of these review companies have nurse practitioners or nurses that kind of set up the case for the doctor. Those, by time it gets to the doctor, the decision's pretty much already made as to what that doctor's going to say. We have the Foltz case where folks other than the doctors were even signing the reports for the doctors. They don't do that anymore. They've gotten a little bit smarter, but in essence, the reports are done and prepped for the doctor and ready to go. And if you look at a lot of the doctors' reports, you see the same faces. You look at their reports, same paragraphs, you know, make those comparisons. Multnomah County motion panel consensus statements, they're not rulings, whatever they tell us. On this DME issue with respect to recordings and with respect to attorney attendance, I'll give you a little bit of history. Way back in the year 2000, we could not attend DMEs. Couldn't do it. That was the Multnomah County rule, and that was what was followed. And you couldn't record back in 2000. In 2000, the motion panel reversed its decision because plaintiffs' lawyers submitted a bunch of materials and defense lawyers submitted a bunch of materials to the panel, and they were going to decide which way they should go on it. What they did is they just reversed the rule and said, we're not going to exclude attorneys, we're not going to say no recordings, but we're not going to say one way or another. It'll be on a case-by-case basis. And what they wanted to do was wait and see what the decision of the Council on Court Procedures was going to be. The Council had taken this up, and it was a major issue for the Council back in 99, 2000. And the Council of Court Procedures is a group of plaintiff lawyers, defense lawyers, and judges that make changes to the ORCP. And in that committee, it was pretty much done that they were going to make the change that permitted attorneys to attend and permitted recordings. Unfortunately, it got sidetracked, and the Council of Court Procedures requires a supermajority of 2/3, and they fell one vote short. They needed 15 to pass it, and it would have been the ORCP law. They had 14 votes and needed 15. What the Multnomah County panel did, though, is they kind of split the baby. They said, okay, we're going to allow recordings, but we're not going to allow attorney attendance. So what in effect they did, even though the majority of the council said we should have both attorney attendance and we should have recording, they decided that we're not going to have attorney attendance. So basically what they did, they said, well, let's wait and see what the Council on Court Procedures says. Council on Court Procedure and a majority said we should have both, but they didn't follow it. They split it so that now in Multnomah County you can get a recording, but you need to make some kind of a showing that attorney presence is necessary. And I've tried a couple of times, and they're pretty adamant that they're going to follow their local rule, which they say is not a local rule. Yes? I believe it does. They don't want other people there, not just the attorney. Yes, that's a good point. I have a long list of about 25 things, and you can agree. They usually agree on 10 of them, and then you decide which ones you want to argue about. I try not to argue about all 15 of them because then they throw that up in front of the judge. I try and make my 2 or 3 main points that I want to get. the couple of cases that I think are important, one is the TriMet case, 308 or 185. And in that decision, the Oregon Supreme Court reversed the decision of the Court of Appeals and reinstated the board's award. This was a workers' comp case, but I think you can use this case. The Oregon Supreme Court found that the insured's insistence on having an attorney present when he was examined by a designated physician but did not constitute obstruction of medical examination requiring suspension of insured's rights to compensation. In other words, they wanted to suspend because the attorney was going to be there. In rejecting the lower court's assertion that the presence of an attorney might affect the neutral setting and the objective environment of an independent medical examination, the court quoted the referee, "I do not find much merit in the objections raised by the proposed examiners in this matter. Claimant's attorney has agreed to do nothing more than observe. The examiner's suggestion that attorney's presence would taint the examination is patently absurd and only bolsters concerns over examiner objectivity." I think that needs to be read to some of the judges in Multnomah County.
Are you sending observers or trying to record PIP IME?
Sometimes I do. They will oftentimes object to that, and so then the issue is, do you want to deal with them cutting off your PIP benefits, cutting off your client's PIP benefits at the IME? But my thinking is, I'm not sending many people to IMEs from the PIP carrier. I would rather just have my benefits cut off if I can in that particular case, talk to the medical provider, try and get the medical provider to continue treatment anyway. Sometimes folks do send because they just feel like they have to. They don't want to be, the attorney does not want to be responsible for cutting off their benefits. But given the percentage of cutoffs anyway, I just have a hard time sending them. Bill? You're right. You can't just tell your client, me attorney says don't go. But you can be pretty persuasive with your client.
Are you having any trouble when you do that sometimes with the Blue Cross or some other medical providers saying, we don't have an exhaustion limit here, so why are you paying for this?
I've seen that before too, and then you do have to fight that battle. But the bottom line is that they're secondary, and if primary is not paying, then they're supposed to pay according to their contract. I don't know that it says anywhere in their policies that you have to go to quote unquote, and from our perspective, a biased medical exam to continue your benefits. Yes.
You mentioned that try to get the other side to get a court order to get the DMEs, and in there you try to get certain your 2 or 3 main points to be ordered. Have you been successful in having the judge order this to get financial information? DME, is that one of the things they can get?
Yes, and recently, Judge Jones, who was doing a lot of the of these expedited motions, 2 cases right in a row, ordered that they had to give some financial information.
Everybody, of course, is sharing that information with all of us, so we can all have it.
Correct. That's the way it's supposed to work.
And my other question is, are you also successful in limiting, when the other side says it's an issue of contention, you got an X-ray case, and it lasts more than 8 weeks, so they assume, of course, that only Dean and Hines can evaluate this person's condition. Or, I'm sorry, I just forgot the name.
Should they have psychological problems if they're treating after 8 weeks?
Right, because after 3 weeks, they decided an issue with the mental condition that you've never played. Can you keep, will the judge's order to keep that from happening?
To keep the psychological...
To not have the psychological DME as part of the panel, because you've never alleged it.
I don't know. I would think, if it's not in your complaint, why are we sending somebody to a psychological DME? But then there's some judges that believe, there's emotion in psychology in every injury, and therefore you've got to allow for that DME. But I think you can make some pretty strong arguments. I haven't really dealt with that. You guys, you're into your your break time now. Say that again, I wasn't listening. I'm asking her what she said. Okay, so Judge Jones ruled that if you're claiming physical injury only in your complaint and they are requesting a psych exam, he was not going to allow the psych exam. How's that, Peter? Okay, I'm going to quickly wrap up here. Keep in mind that DMEs and IMEs, particularly in auto cases, in my opinion, is the most important procedure in the case. In most of these auto cases, we don't take them unless liability is pretty certain. So the issue is injury. So the most important procedure is a PIP exam that may kill your case right out of the chute, or an ORCP 44 exam. Would you send your client to a deposition unrepresented? Peter thinks that maybe you become a witness. How many of you have become a witness because you attended the deposition with your client? Tom doesn't like that analogy. But that's the kind of argument you've got to make. California has had attorney attendance for years. Washington has had attorney attendance for years. Attorneys in Washington and California do not become witnesses because they attended the examination. And so long as you got a recording too. Keep it recorded. Why shouldn't you be allowed to attend? As I said, the PIP case can blow up in your face from the beginning. 90% of our cases settle. The examinations are important even if you think you're a great cross-examiner and you can kill the DME doctor at the end. Thanks.
Thanks to, I guess, at least it was Rob Wolf's suggestion, we're going to have a little meeting at the end of this, so let's not cut into that. Our next topic is, our next speaker is David Morrison. David comes to us from Roseburg. Practice primarily focuses on workers' compensation and personal injury. He does a lot of auto accident cases. In '75, he got his JD from the Antioch School of Law in Washington, D.C. He received the OSB President's Public Service Award in 1989. He's a former member of the OTLA Board of Governors, currently serves as the president of the Umpqua Community Development Corporation when he's not fly fishing on the Umpqua River. We're glad to have his topic because I'm finding something more and more on some small cases that come through. I'm getting stiffed with these stupid Colossus offers that are absolutely unfair. And the purpose of 20.080 is to sort of even the playing field, and I try personally not to take a lot of them, but I think it's still an area like Dean Heiling was talking about, where if you can get paid for your time and still represent your client, then you get the money out of the insurance company, and that's really nice. One tip on that, everybody should look at your fee agreement with your client, because what you need to have is, there's an old case, and I've forgotten what the site is, but you have to have a provision in your fee agreement that allows you to either take the contingency or the award of the court, or you can even say that you get the best of the two. But if you don't do that, you have to take the court award. And so that's just a practice tip. But to tell us more about the cases themselves, please help me welcome David Morrison.
Well, the day is wearing on. Lots of information has been coming your way, so I'm going to try and be as concise as I can on the subject of 20.080. Before I do that, though, one very quick comment on Peter and Tom's presentation on conditional DMEs. I want to tell you, as you know, I practice in a rural jurisdiction in the southern part of the state. It is much more conservative generally, both on the bench and among the jury pools than typically you have here in Multnomah County. And there in Roseburg, with a very middle-of-the-road conservative trial judge, I was able to get a conditional DME order which not only imposed the conditions that were being discussed, but also very strict requirements as far as financial disclosure, which were so strict that the original doctor who was scheduled to do the exam said he wouldn't do it under those conditions. And they had to go scrambling for another one. The order is in your materials, actually. It's included in the materials that Tom and Peter submitted. I will tell you that I also have, and will be glad to make available to you, a transcript of a 20-minute speech by the trial judge as to how corrupt the system of DME exams has become and how it's crying for reform, and it's time that somebody did something about it. So get hold of me if anyone would like a copy of that transcript. It is also in the DME bank. Now on to ORS 20.080. My disclosure and disclaimer, first of all. I believe Steve put out a request for ideas for topics for this seminar. I had just within days had an ORS 20.080 case that I had resolved, but it had gone a little bit sideways on me. I was scratching my head about some of these things that I had not come up with before, and I suggested it to Steve, and he said, fine, how'd you like to do it? So be careful, you might get what you wish for. And I also, just so you know, I'm quite sure that there are a number of people in this room who probably have more practical experience in actually handling these 20.080 cases than I do. And so do not hesitate to correct me or add your comments if you think that they're helpful. ORS 20.080 is a wonderful tool for plaintiffs' lawyers. And what Steve said is true. It is a way to spend time on the smaller cases and have the possibility actually of making some money on them. There's another aspect to this, though, that I have to say, which is it's one of the rare times that you actually can get the attention of an insurance adjuster who's just blowing you and your client off. And if you don't get their attention, all the better, because they let that 10-day period go by. You file your claim, and then if they haven't made an offer, you've got a very good shot at getting attorney fees for your time. And we'll be talking about the various aspects of this. Let me tell you what we're gonna cover. I want to talk to you a little bit about the history of this statute because it's interesting and I think it's relevant to the purpose behind it. I'm going to talk a little bit about the applicability and the scope of ORS 20.080, and that came up earlier in the day, and I think we'll be talking about that a little bit. I want to talk with you a little bit about the compliance and notice requirements under the statute, a little bit about PIP issues and how PIP issues do or don't interrelate to 20.080. Tenders, there's a very interesting recent Court of Appeals case on tenders. I want to also talk about the tension, or at least the perceived tension, between ORS 20.080 and offers of judgment under ORCP 54E, which was interesting for me when I looked into it, and also just the question of fee awards and the amounts of fee awards. So let's go back to the history. This statute dates from 1947, and it's a breath of fresh air to read the statute. It's also a breath of fresh air to read some of the case law that interpret it, because in our time, it's so rare to see language which is so supportive of the problems and the situations that our clients, injured plaintiffs, find themselves in. And it's encouraging when you go back to, for example, a case we'll be talking about here in a moment, which is a 1956 case, the Colby case, which has some very, very interesting language in it. Let me just give you that language. And this was a case in which, and in fact, to my knowledge, it's the only reported case which determines whether or not ORS 20.080 cases are subject to offers of judgment under ORCP 54E. And the court said, this is 1956, frequently the injured person might forego action upon a small claim because he realized that after paying his attorney, net recovery would not be worth the time and trouble of a vexatious lawsuit. The legislature may have found that tortfeasors or their insurance carriers frequently rejected meritorious claims of this kind because of this known reluctance of injured persons to litigate. Claims which in honesty and fairness should have been paid were not paid. And I'm hoping the farmers' insurance people will hear that language someday. And it was to remedy this evil that the statute was passed. And that's Colby versus Larson. So that's the historical background of the statute. So what does ORS 20.080 apply to? The language says to tort actions involving claims for injury to person or property. It was mentioned earlier that the 2001 legislature enacted a companion statute to 20.080 to deal specifically with contracts. And in some ways, I think that takes the wind out of the sails of a case, a fairly recent case from the Court of Appeals called Mitchell versus City of St. Paul. And that's a 2001 case in which the court went through a number of mental gyrations to find that the attorney fees requirement in 20.080 did not apply to an owner's breach of contract action due to the fact that the breach did not result in an injury to property beyond the financial benefit of the contract itself. And in the course of that, it talks about all the different types of cases where they've sort of stretched over the years to make 20.080 fit. I've included the text of the 20.082 in the materials. It's basically the same. However, it does specifically exclude contracts of insurance. And I believe that question came up earlier when Dean was giving his presentation as to whether or not you could sue on a policy or failure to settle a policy under 20.080. And my reading of the language of 20.082 leads me to conclude that you cannot do that. So who do you have to give notice to under the statute? And by the way, I'm I suppose, primarily a lurker on the listserv as opposed to one of the more active participants, but there are a lot of postings about ORS 20.080, and I've learned a lot just from watching the postings and the responses on the listserv. The statutory language says that there is a requirement for a written demand for payment made on the defendant. One of my favorite case names, Schwarzkopf versus Shannon the Cannon's Window and Other Works Incorporated, was a case which addressed the question of whether or not sending the notice to an insurer who's acting as an agent for the defendant it meets the requirements under the statute. You can certainly read that case, and I believe in that case they found that the answer would be yes, but under the facts of that case it wasn't clear that the insurer had identified or established itself as an agent of the defendant, why not just send your notice letter to the defendant? Or better yet, send it to the defendant and the insurer, or to the defendant and the insurer's attorney. I think that the advisable thing to do is just don't tempt having a defect in your notice by not making sure that it goes to the defendant. Another interesting case having to do with whether or not you can split your case in order to get two halves of it within the monetary limits of the statute. And look at Beers versus Jessen Enterprises. That's also in the materials. A very interesting case. This is a 9-page en banc decision by the Court of Appeals with a concurrence, and a partial dissent, and a full dissent in which the senior judge only somewhat respectfully registered his dissent under facts in which a notice was sent to a defendant involving a wrongful prosecution, malicious prosecution for a shoplifting case. The plaintiff ended up filing two cases, two claims, each of which was at that time at the 20.080 limit of $4,000. The two cases were consolidated at the trial, and the result was an award of $8,000. The Court of Appeals held that the plaintiff was entitled to attorney fees on half of that $4,000. A very strange decision, but again, as a general principle, I think you're going to have a claim that is now under the $5,500 limit.
Does that decision indicate that the notice had to indicate a willingness to settle for an amount under the $55,000 or $4,000?
The notice in that case was also an issue in the decision. Let me give you the case. The demand letter in that case was for $4,000. And what happened was they ended up filing two claims, one for malicious prosecution, and the other one was for false imprisonment. Most of these cases will typically involve the low end of motor vehicle accidents, obviously because of the $5,500. The question that has come up, and this has come up on the listserv I know, is how does the PIP reimbursement figure into the demand that is made on the defendant under 20.080. And I cite the case to you in the materials of Gish versus Lawless Roofing, in which the Court of Appeals, to my surprise, held that if the PIP insurer has advised you that they intend to pursue a reimbursement of their PIP on their own without any assistance from you, then that frees you to plead your 20.080 case exclusive of the PIP amount that the insurer would otherwise have you collecting for them. And that's a very handy thing to know, because that gives you a little bit more leeway in getting your claim under the $5,500. Mike, Bryan, and I were talking earlier today about a more recent case, Reed versus Jackson County Citizens League. And this case has to do with the question of what is a valid tender under the statute, which then would preclude your right to obtain attorney fees if the award is not greater than the tender. And in that case, which was a 20.080 case, the defendant made a tender in an amount which was equal to the amount that was ultimately awarded at the arbitration. But they attached certain conditions to the tender, which were for a full release of the claim and provisions of confidentiality. And this is a Court of Appeals decision dated July 31st of 2002, in which the court went through a fairly extensive analysis of the law of tender. And I won't go into all of the details of their analysis, but they found that the tender that had been made in this case was defective because it included conditions which were not inherently permissible under the law of tender. Therefore, plaintiffs were entitled to attorney fees even though they did not beat the tender offer. And based on Reed versus Jackson County Citizens League, be very important for you to read very carefully what language is attached to the offer that you may receive from the defendant's insurer. I'm interested in how many of you here have had handled 20.080 cases in which, before you got to your arbitration or your trial, you received an offer of judgment under ORCP 54E. Okay. My sense is that this is something that is discussed among our opposition colleagues, and it's considered to be a fairly standard way to try to defeat your right to attorney fees. And I did not know, this was one of the issues that came up in the case that I had handled, that 20.080 is not subject to, it is not controlled by ORCP 54E. And for those of you who've had these offers come in, I'd be interested to know if you have been successful in arguing that ORCP 54E does not apply. Yes, okay. All right. The case to read, again, is Colby, the 1956 case, which says specifically that it doesn't apply, and it's still good law. Carl Crowell, I don't think Carl is here today, has done a lot of work on this, and he does have a memorandum which he has drafted, which I'm sure he'd make available for anybody who has to argue this issue. On the amount of attorney fees, Dean Heiling just very recently obtained an attorney fee award in a 20.080 case of approximately $10,000. And it is possible, that was about 39 hours of work, I think, that he'd done, and he persuaded the court not only to award him his customary $200 per hour, but there was also a lodestar in there as well for the contingent nature. Dean's memo, Dean sent me a copy of it. Actually, it's his affidavit. I'm sure if any of you would like to have a look at it, get hold of Dean and he'll make it available to you. But basically, the cases that I cite in the written materials hold that the amount of the award in an 20.080 case does not control the amount of the fee, and by all means you should keep careful track of your time and don't hesitate to argue that your attorney fee award should not be bound or limited at all by the award. Questions? I think the answer is yes, because the language of the statute is very clear as to what's required in the notice. Yeah.
That's exactly what I do. I just mail a letter, certified mail, return receipt requested to the bad driver. They're not even bothered with the insurance company. If they don't get it to their insurance company within 10 days, I file on day 11. And that locks in my ability to recover fees. Repeat that, please.
Okay, the question was, in your notice letter that you send out to the defendant, are you required to include any detailed information about the nature of the injuries, the cost of the medical treatment, or anything of that nature? And the answer is, based on the language of the statute, and this is one of the beauties of this statute, you don't have to. And the point, I think, is that it is intended to be a remedy for not getting the attention that ordinarily you are required to have when you make a claim like this to an insurer. Yes?
I have a question. Kind of hypothetical. Let's say you have a plaintiff with a child, small MBA case. Do you have to file separate action for the child and for the parent?
Well, okay, the question is, if you have a minor small-scale motor vehicle accident with a parent and a child, do you have to file, can you file them in the same action, or should you file them separately? I think the consensus here is separate. And the reason for that is because you have more leeway with your damage claim if you file them separately. Thanks very much.
Our next speaker is Judy Hudson. Judy received a law degree from Willamette University. She's got a BA from Hamline University. Judy, I don't know where that is, so maybe you can tell us where Hamline is. Member of the OTLA Board of Governors since 1997. Judy's one of the troopers. She's been active in a lot of things with OTLA, publications, public education, education, legislative, and the appointments committees. She is also another member of the President's Circle, and she's going to talk to us about an area that we all like to talk about. You know, that case where we're finally looking at something that might actually be some bucks of policy limits offer, but it's also an area that can be a minefield. So, Judy, walk us through it.
It's in Minneapolis. For most of us, that perfect case walks in the door with an absolutely great liability, no question about it. The injuries are hard injuries, and you get real excited. You call the insurance company, or you get a call from the insurance company saying, well, it's a 25 policy. And I would venture to guess 80% of the cases that I start out thinking are going to be absolutely wonderful turn out to have a policy limits problem, in that there aren't enough limits. Rarely do you have a great case and great injuries and no insurance policy problems. That being said, then I think we need to spend a few minutes now talking about what do you do in a situation where there's simply not enough money to go around and it is a limits question. The first thing I would suggest is look at the policy if at all possible. So if you have a plaintiff and you're pretty sure within the first month to 6 weeks that it's going to be a minimum limits case, meaning that it's going to be beyond the $25,000 statutory limit, call the adjuster. And I usually am very blunt and will pick up the phone and talk to the adjuster and say, look, I've got $15,000 in medical expenses. It's 6 weeks. They're going to be out of work for the next 2 months. If you have a minimal policy, I really need to know now because it's going to affect how I handle this case. 9 times out of 10, the adjuster will say, yeah, I can tell you it's a 25 policy or it's a 50 policy. If they will tell you that, don't take their word for it. Ask them, please send me a face sheet of the policy. I can't tell you the number of times that I will be close to settling the claim and get a call from the 4th or 5th adjuster in a long line of adjusters and say, oh, actually it's not a 25 policy, it's a 50 policy. Well, I will have just represented to insurance lien holders that I was dealing with a 25 policy, and now I'm going to have to start from scratch and work all of my deals all over again. So if at all possible, get a copy of the face sheet and look at it. Every once in a while, you're going to get a grumpy adjuster, and they're going to say, gee, I'd really like to give you that, but it's privilege, and I can't help you. I can't tell you what the policy limits are. Well, you've got a couple of choices. You can file and get that information, and some of them simply need to be reminded of that. Or you can send all the documentation and begin the process of setting them up for a bad faith claim. But really, it depends on the adjuster, and I have to tell you, I don't have that much difficulty if it's a clear policy limits case of getting them to tell you yay or nay. Once you know what the defendant's policy is, you want to ask whether there's any additional coverage. Is there an umbrella policy? Most of the time, the adjuster will agree to call their insured and ask. Sometimes it's with the same carrier, and they know, and they'll tell you that. After you find out there is or there isn't, if there is, you want the policy. In about half of the policies, autos are excluded from the umbrella policies, and the other half, they are not excluded. So you need to look at the policy itself. Once you're sure you know what money is available on the defendant's insurance side, look at your own plaintiff side. Are there other policies that might come into play? This particularly is helpful in a minor child with divorced parents, because joint custody is so prevalent now that it's not unlikely that you have 2 parents, each with a different auto policy and some with different limits. So while one parent, you may not have UIM coverage available, you may well have UIM coverage available on the other side. So, and that goes up to a college-age kid. So just because you have someone over 18 doesn't necessarily mean that they're not going to be covered by their parents' policy. So up to age 21, 22, sometimes you can find available coverage there. Again, you want to look at an umbrella policy. And then thirdly, you want to look at disability policies. It will come into play in determining how you have them use available benefits. Standard has 2 policies that they routinely write that don't have to be reimbursed, and you do not have to use the primary policy first, meaning the PIP policy. So if someone's especially insured with Standard, you want to get the policy and look. Because if you've only got $25,000 and you're attempting to build your damages, you may not want to have your client spend 15,000 of those damages under the PIP policy. So it pays to look at what disability policy is out there. Once you know that it's a 25 policy and you can't find any other money anywhere else, you're tempted to say, okay, that's it, let's close it out and move on. But there's some real advantages, especially for your client, not to do so. First, it's the PIP offset. They're going to be entitled to a PIP offset of damages. So you need to build the damages. You need to know what those damages are before you accept the $25,000 tender. So that means you got to wait a while until the majority of those medical expenses are either incurred or you have a reasonable knowledge as to how much they're going to be. Secondly is health insurance liens. A health insurance provider or carrier has a contractual relationship with the medical provider. So their fee for service is substantially less than what your patient or your insured, your client, is going to pay to their doctor. So it is far better for them to have their insurance company, health insurance company, pay that bill than for them to attempt to pay bills out of the settlement. And so again, that takes time. You probably need to wait until you have a relationship with the insurance provider. For example, I had a case a couple of years ago with a kid who was 16, 17 years old, had his leg crushed. He had about $275,000 worth of medical bills, and an insurance policy of $300 was all we could find. OHSU stopped billing the health insurer. They simply stopped. I called and, why aren't you billing the health insurance? My client keeps getting all these medical bills. They were very blunt and said, well, if we bill your client directly and they have to pay us out of the settlement proceeds, we're going to get almost double what we're going to get because of the insurance contract we have with that particular carrier. Well, it didn't work. Essentially, we said it isn't going to happen. If you keep going down this road, we'll have trouble. They eventually began to bill the insurance company some more. The insurance company paid, and then when we settled the claim, we were able to settle with the insurance company at a substantially reduced level than what we would have had to have paid if we had to pay the bill directly. For those reasons, although it's tempting, don't take the 25 and run. You really do need to make sure that the bills are paid appropriately. You want to look at trust agreements, read them very carefully. Sometimes you will get an agreement immediately from the health insurance provider that says, you hereby agree to pay out of the proceeds of the settlement our lien in its full amount. Well, you don't want your client to sign that because there's an argument then that you may not get paid. So you don't want to sign something like that. I'll usually cross that out and say to my client's portion of the settlement, or I'll stick it in the file and ignore it for a while because I'd really rather not sign it at all if I can get away with it. And sometimes you can wrap it up long before they start realizing you haven't signed a trust agreement. So if at all possible, don't sign it. Stick it on the back burner, and sometimes there's no real requirement to sign it. You'll need to look at your client's actual health insurance contract. The second area, and we talked about it briefly, was PIP offsets. If you have a $25,000 case and you have a PIP lien of 10 for medical and 15 for wages, your damages then are $25,000. Are they entitled to a PIP lien or a PIP offset for the amount they paid? The way it works is the PIP carrier does not have to be reimbursed if the total amount of the damages exceed the available policy. So you add up all the insurance policies, total them up, add up all your damages, and if your damages are more than the available policies, there's no PIP offset. Yes. That's limited to economic damages. So that's why I would say earlier, knowing the amount of those medical bills and how much that wage loss becomes exceedingly important in being able to accept or not accept the tender of a $25,000 policy limit early on in a case. Once you know what the policies are available, and what your damages are, then the next thing you have to look at is what does the defendant have? Is there anything else? Are there any other damages out there that I can get? And you can do it in a variety of ways. If it's a small case, I'm usually tempted to develop a questionnaire, send it to the insurance company and say, will you please have your insured sign this, notarize it, and get it back to me? If it's not, or if I think for some reason the defendant may have other assets I'm not familiar with, then we'll ask for an asset deposition. The third route is getting a professional asset study, but that's really only going to give you information that's a matter of public record. It's inexpensive, but it will tell you whether or not they own any property. Any way you choose to do it, you need the following information. You need to know about income. You need to know about where they work. You need to know about the employer's bank and bank account numbers, if possible. You can usually get them off of a pay stub. Interest in real property, stocks, bonds, cash. Now, the next one is a safety deposit box, and I learned the hard way that this is a matter of interpretation. I was clerking for a firm that did criminal law as well as personal injury law years ago, and I was sent to represent this criminal in a civil action that had been filed against him. And the attorney asked, do you have anything stored in a safety deposit box? Well, my client looked at me and said, can I see you outside? I thought, oh, okay. So we walked outside, and he said, a safety deposit box is at a bank, right? And I said, well, generally speaking, that's correct. We go back in. He said, I don't have anything stored in a safety deposit box in a bank. Well, I completely forgot about the incident until about 3 months later, and one of my other chores was to go out and collect from this man on a bill he owed the criminal attorney in the firm. So I went out to his home, and he said, well, come with me. Well, we walked outside the back patio, down a little pathway to what looked to me like a dead flower garden. And he picked up a plant about this size and just picked it up by the roots, dusted off a little box underneath it, and there was, I hesitate to count how much cash in that little box that he had. And it finally dawned on me that that's what he had been talking about previously, that he considered that his storage box or his safety deposit box, but it wasn't in a bank. So what you want to ask somebody is, where do they store their valuables? Not do they have a safety deposit box, but where would they store their valuables? We all have a little bit of different interpretation of what's valuable and where to keep it. Look at personal property and go through briefly a list of personal property. The other one is trusts. Are they a trustee? Are they the beneficiary of a trust? Are they scheduled to inherit anything? This was another one that was very interesting a while back. I took the asset deposition of someone in a case that, from all apparent views, he had nothing, absolutely nothing. And yet, after we finished the asset deposition, and I have to admit, I decided early on, looking at him and looking at his house, he had nothing. So I went through the perfunctory questions and figured he didn't have anything. As we were leaving and the court reporter was closing up her material, I happened to notice that there was a Catlin Gable newsletter on his stack of papers. And so I just asked him, I said, well, did you go to Catlin Gable? And he said yes. So I thought, well, maybe Catlin Gable, for those of you who don't know, is a fairly expensive private school in Portland. So I kind of wondered, and then I said, well, why did you go to Catlin Gable? And he said, my parents and my grandparents considered it very important. And besides, my grandfather's obituary is in that notice. And I said, oh, really? He hands it to me and looks at it. He was probably one of the most wealthy men in Portland. So I then said, did you happen to inherit anything from him? And he said, no. The attorney told me it's not going to come through for another 6 months. So I immediately grabbed the court reporter and got her back and said, could we put all this on the record? And he was as friendly as could be. hadn't a clue what that might mean, but it got us an additional $150,000 in an agreement that we wouldn't have had. So what I'm saying is things don't always appear the way they actually are. And when you're looking for assets, you want to ask the right question. And what the right question is for you may be entirely different than what it is for me. So look around and ask the questions. History of bankruptcy is also a biggie. You want to find out whether or not they've ever filed and whether they've transferred any property within the last 4 to 6 months. After you get all through that and you are comfortable that the defendant really doesn't have anything, so all there is $25,000, then you need to contact the PIP carrier. And you need to talk to the PIP carrier about releasing the defendant for a variety of reasons. Now, there may be an argument whether you actually have to do that and what would happen if you didn't do that, but why go down that road? I have never had, if I've done an asset search, a PIP carrier tell me, no, I'm sorry, you can't release the defendant. If I have done the work and I'm comfortable that there isn't anything else there, they will always say yes. But get it in writing. Because by statute, your client has a duty not to prejudice the rights of the insurance company and to fully cooperate. So technically you may be able to bypass that if you've set it all up correctly, but I guess I would say to you, I'm not sure you need to. If you do your homework, call them, make the call, they'll put it in writing, and that's the easiest thing to do. We've talked a little bit about the case in which $25,000 is all there is and you have a clearly excess case. For most of us, that's not the way it happens. For most of us, we have a case that might be worth $17,000, and how do we get it more like $25,000 and get them to tender their policy? Much of it, I would say to you, is an attitude. It is an assumption that your case is worth $25,000. I practice with a man who does this more often and much better than I. But we have a practice in our firm to evaluate the cases together, and we put them on little sticky pieces of paper, and we staple them in the front of the file, and we usually have wagers on where they actually settle, but that tells us whether or not we're pretty close or we're far apart. And invariably, he will say, oh, it's worth $12,000. And yet, invariably, he will get the policy limits on that case when it is close enough to the policy limits. And I have many times said, how are you doing this? He said, I initially call the PIP adjuster and act as if this is going to be a UIM claim, so I need to know the limits, and actually assume from the get-go. And it's amazing how many times the adjuster will have that in his or her mind, that this is going to be a UIM case. And the reaction usually is, well, we might waive the PIP, but that's it. Well, that's fine. You've just gotten a lot more than you had 10 minutes ago. So I would suggest to you, and again, you obviously can't do it with a case that clearly isn't close, but if you have a case that's close, assume from the get-go that it is, contact the UIM carrier and assert that it is, and whether they are supposed to or not supposed to, I'm amazed at the number of times it's very clear that that UIM adjuster has talked to the adverse adjuster, and they suddenly have a similar perception on that case. So sometimes it really is more of the way you choose to handle the case and how you choose to make some certain assumptions than it is anything else on those cases that are relatively close. Now, if it's Allstate or Farmers, it's probably going to not work as well as if it is an out-of-state carrier or one not Farmers or Allstate. Any questions that anybody has? Yeah.
Comment, it seems like it would be ideal to follow that up with the appropriate statutory notices.
Absolutely. For those of you who couldn't hear it, he was saying that it's probably a good idea to follow that up with the statutory notices, and that's absolutely correct. Absolutely correct. Any other questions? In terms of what I send to the carrier? His question was, how do you document your policy limits demand? I probably oversend as opposed to undersend. I am one who, right from the get-go, if I think I have a case that's going to be close, will paper that insurance company. They don't ever have to ask me what's the status on the claim. They know the status because I've bugged them since day one as to, here's the updated chart notes. You'll note that Dr. So-and-so says this, this, and this. It looks like this is going to be a problem for a very long time. So I think the more that you communicate and the more that you set the tone, the better. But the medical records need to go from the get-go because insurance adjusters get a mindset early on as to what type of claim it is. And I have found it's very difficult to change that afterwards. Did you have a question? No. Any other questions? Thank you.